We are going to review the completion of the Pennsylvania Seller's Property Disclosure Statement. At the top, you will start out by completing the property address and the seller's name. This disclosure is required to be completed anytime a seller is transferring a property that is of a single-family dwelling up to a four-family dwelling. There are 10 instances where this disclosure does not have to be completed for a transfer. That is when the transfer is a result of a court order, the transfer is a result of a mortgage lender from a buyer's default or foreclosure, a transfer from one co-owner to another co-owner, a transfer made by a spouse or a direct descendant, a transfer between spouses that's a result of a divorce or a property settlement, a transfer by a corporation partnership to other shareholders of the corporation and partnership, a transfer of property to be demolished or converted to a non-residential use, transfer of unimproved real property like land, transfer by a fiduciary during the administration of an estate or a trust, transfer of new construction from a property that has not been occupied. The first section here pertains to answering questions regarding the seller's expertise. Now, throughout this disclosure, there are going to be columns here where you can answer the questions. There's a yes, a no, unknown if the seller does not know the answer, or not applicable because the question does not apply to the property. The first question here that pertains to asking if the seller possesses any expertise in contracting, engineering, architecture, environmental assessment, or other areas related to the construction and condition of the property and its improvements. This is if the seller has a license in any of these fields or has a lengthy career of experience in any of these fields. Not if the seller is somewhat handy and has done some minor home improvements himself to his home. That does not constitute an expert in these fields. The next section goes on to talk about if the seller has ever occupied the property. In some cases, the seller is the landlord and has never occupied. Also, you will complete here and indicate who is actually completing this disclosure. The next section talks about if the property is of a planned community, a condominium, has part of an association. You would indicate what type here, and as far as the community name and contact information for the management company. Also here it does ask the question if this association requires the new owner to pay a capital contribution fee at the time of settlement. The next section asks about the roof age when it was installed. Has it ever leaked during your ownership? And anytime you answer yes to a question, for example here, has the roof or any portion of it been replaced or repaired during your ownership? And you elect yes. In this section, there's always a section on the bottom that you have to explain any yes answers in this section. So since I indicated yes, I would go on here to elaborate why I answered yes, and that's because during my ownership, the roof has been replaced. Be sure that the seller initials and dates every single page. The next section pertains to basements and crawl spaces. You have to indicate here if the property, of course, has one, if it has a sump pit, if it's working, if there's ever been any attempts to control any type of dampness or water infiltration. The next section asks about if there's been any history of wood destroying insects or any type of treatments to prevent from any wood destroying insects. Just so you know, wood destroying insects are not just termites. There are other type of wood destroying insects such as carpenter ants, carpenter bees. The next section talks about any structural issues with the property. If there's ever been any shifting or deterioration with the property. Also, if there's any construction of stucco or synthetic finishing systems. In this section, it asks if the property has ever been a victim of firestorm, water damage, ice damage. Section 8 talks about any additions or structural changes, modifications done during the ownership. You would specify here the date the improvement was made and if any permits were obtained and final inspections performed. The next section talks about the water supply. If it's a public source, then you would check public. If it's of private, then what type of private system is it? Is it a well? Is it a community water, a holding tank? And then these next questions ask and pertain to if you do have a private system, these questions would pertain. If you have a public, it would not, except for this section here in E and F. If your water has ever been tested, even if you have public water, it's possible that you've had your water tested. Also, if there's any leaks or plumbing problems in the house is in that section. The next section pertains to your sewage system, if you use a public one or a private. And then if you use a private one, there's much more extensive questions in these next sections, C, D, E, F, pertaining to a private septic system. Section 11 talks about and requests what type of plumbing systems you have. It's very common that in a property there could be more than one type. A lot of homes have copper and PVC present day. So, it doesn't necessarily mean there's only one answer here in this section. On the next section talks about how the water is heated in the property, what source is used, whether it's electric, gas, oil, or some of these other options. Section 13 asks how you have what type of heating system you have. Also, sometimes you can have more than one type of heating system in a property. You can have an electric heat pump that has an oil backup. So in this section, you would actually check yes to electric and oil. Then you also indicate here how the heat is delivered through the house, whether it's through a forced hot air system or a hot water delivery system like baseboard or radiant. In this section here, you also indicate the age when the last time the system was serviced. Here you also indicate if there's any fireplaces on the property, if there's any chimneys on the property. Oftentimes people don't realize that your heating system can have a chimney. So sometimes people think if I don't have a fireplace, I don't have a chimney in the property. That's not the case. A lot of type of heating systems use a chimney flue for the exhaust, like oil and gas. Also here, it questions if there's any heating tanks on the property. Sometimes they're not in use anymore, that they can be buried underground, so you have to disclose that here if that is the case. Section 14 talks about what type of air conditioning is in the property, if it's a central system or if there's wall units or window units. Section 15 asks about what type of electrical system is in the property, ampage. Section 16 talks about what appliances are in the property and plan to be left with the property. Just want to clarify here, if a seller does indicate there is a washer and dryer on the property, and then come time at offer and contracting, under inclusions on the agreement of sale, washer and dryer is not indicated as an inclusion, then that supersedes what was disclosed on here. If it's not on the agreement of sale, then it's not an inclusion. Section 17 asks regarding the land and soil of the property. Also in this section and these other letters here, it just talks about if there's any type of preservation or any type of Open Space Act or things, special conditions that the property has to maintain under certain guidelines. Also, because this is a statewide contract, we don't often see that there's any type of mineral rights to the land, but there could be some parts of Pennsylvania where this will pertain. And again, then you would indicate the answers here. Section 18 asks about any type of flooding or wetlands or drainage issues on the property. Also in this section, it talks about any type of easements, encroachments, any boundaries, shared driveways, alleyways, private roads. You would disclose here if it pertains to the property. Section 19 goes into any type of hazardous substance like mold or radon. If you have any previous testing reports, you would indicate that here. If you've ever had any type of preventative things you've done to the property against mold or radon, you would disclose that here. Also in this section, you find lead-based paint disclosure hazard. If the property was built before 1978, you have to disclose if there's ever been any testing for lead-based paint or any knowledge of any on the property. Also here in this section, it asks again about any tanks on the property. This miscellaneous section goes into any restrictions or issues with transfer of the deed and the title of the property. Also the financials, if there are any arrears or if there's any judgments or mortgage foreclosure threats against the property, you do have to disclose that. Also, if there's any legal threats or actions against the property, they have to be disclosed. And in addition, here at the end, if you know of any other material defects in the property that weren't specifically asked and questioned on this disclosure, there is a section here where you would actually go ahead and add that information. Just because it's not asked does not mean you shouldn't disclose. Again, the purpose of this is to disclose everything, as much knowledge as possible, because once a buyer reviews and signs this, it releases the seller of any liability of lawsuits in the future. So the more you disclose and get the buyer to accept, the better position you'll be in. Lastly here, there's a signature line for an executor. And a lot of times when there is an executor of an estate, they feel, again, it's one of those cases where the disclosure does not have to be completed when it's a transfer of an estate, but it clearly says here, according to the provisions of the real estate disclosure law, the undersigned executor, administrator, trustee is not required to fill out the seller's property disclosure. The executor, administrator, or trustee must, however, disclose any known material defects of the property. So if the executor does happen to have knowledge because it was mom's house and he does recall that the roof did leak at one time, which he facilitated and gave reference to mom for a roofer who came out and repaired it, that is a direct material defect that that executor has knowledge of, and he is obligated to disclose that. So that is the disclosure.